Bernardo Homolka case. It haunts us still. Yesterday, the final arguments in the case against Ken Murray, Bernardo's original lawyer. Murray is charged with obstructing justice because for 17 months, he secretly held on to videotapes that implicated Karla Homolka in the torture and murder of two teenagers. The Crown argues that Murray became Bernardo's accomplice by withholding the tapes. The defense maintains that the tapes were part of Bernardo's defense to be released when Homolka took the stand.
I want to start with you, Walter.
Okay.
There's no question that Ken Murray was in a difficult situation when he learned that he could find the Paul Bernardo tapes. Did he make the wrong decision?
Oh, he made the wrong decision to go get those tapes because he made his position worse. He couldn't, of course, have anticipated what has happened, this sort of Americanization of criminal and prosecutor relationships, with the prosecutors deciding that they're going to charge defense lawyers whenever they can, or we may be seeing the beginning of that. The introduction talked about clearing up issues. I think that this case marks the beginning of a new era in the relationship between defense lawyers and prosecutors, and I don't think Ken Murray could have anticipated it. We really don't know what was going through his mind, but I think we make a mistake if we characterize this as exculpatory or not exculpatory evidence, incriminating or exculpatory evidence. He had something in his hand that I can see might well have moved the prosecutor to do something for his client. He had evidence that Homolka, a woman, was a depraved sexual predator. At that time, it was 93 or 94, we had the Toronto Star Daily bombarding us with how women are abused. The prosecution had bought into the abused wife syndrome. The Attorney General was Marion Boyd. And he may well have intuited, without quite understanding that it's not exculpatory or it's not inculpatory evidence, he may well have intuited, understood. The prosecution may not want this material to become public. And maybe I can do something for my client with that. Because remember, there's a political interface between the Attorney General's office and its legal obligations, its obligations to prosecute, and its political obligations.
Under what circumstances do you have to hand over evidence?
If it's a smoking gun. Yeah. Somebody comes into your office, the classic one that I've heard is he says that he's just been charged with robbing the Royal Bank, and you get to the part about discussing your fee, and he reaches into a bag and takes out some money that bears the Royal Bank seal on the outside of the package, and he opens the seal and tries to pay you with, it's pretty clearly the proceeds of the crime. You have a duty to tell him you don't ever want to see that again, and if it is left with you, you may have to turn it over.
So we have some consensus here that there should have been disclosure of these tapes at some point. Can you tell me at what point, Walter, you think it should have occurred?
After Karla Homolka was pinned down, which the Crown avoided like the plague. They must have smelt that something was out there that could hurt her and could destroy their position that was resting on her. I remember being on this program before the trial started and saying, imagine having your case rely on the credibility of Karla Homolka. So they were protecting her from any kind of attack. And as Murray explained, based on what I read in the press, that he tried to do it at a preliminary, they denied him a preliminary. I would venture to say, maybe the other two panelists can fill in on this, I would venture to say that you get denied a preliminary hearing in maybe 5% of the cases that go through the system. 95 or 97% of the cases involve a preliminary hearing. Bernardo was entitled to such a preliminary hearing. It was entirely reasonable for Murray to expect to have such a preliminary hearing, but the prosecution may well have known. He was entitled to cross-examine her at the assault trial. They withdrew an assault charge. You don't withdraw a domestic assault charges in Toronto. It doesn't happen. But they did it in Bernardo's case. Again, he couldn't cross-examine her, and ultimately he was going to do it at the trial.
We understand that part of Ken Murray's defense right now is that he had to hang on to the tapes until he got Karla Homolka on the stand and got her to say that she was a lovely and wonderful person. Then he would say, aha, I have the tapes, and he could just demolish her credibility. He says the tapes weren't valuable after Karla didn't have to take the stand. And as you say, the Crown made sure Karla didn't get on the stand. Why not turn the tapes over after he realized that the jig was up and he wasn't going to be able to prevent the defense that he wanted to.
He could have done it at the trial, although it was of far less value. It seems to me now, in retrospect, it seems like the great value in those tapes was somehow convincing the prosecution that they didn't want to go to trial and have those tapes presented. Once the Crown somehow got into a position where there was going to be a trial, I think the value of the tapes diminished dramatically. And again, I think the nub of it is the whole notion of women and criminality and depravity. And that's why we got into the mess we're in now. I think that's at the core of this. This was so rampant in 93, 94. We had an NDP government which had given up sort of its economic basis, political basis, and had gotten into the politics of identity. And we had all of this floating around. And so I don't think at the time they would have changed the deal. Traditionally, women do better than men in the criminal courts. If there's a couple that are charged with an offense, usually the fella takes it, the male person takes it, and the woman is dealt with in a less severe way.
But right now, I mean, some have suggested, some columnists have suggested that Ken Murray is really the fall guy, that people are very angry about Karla Homolka's deal, and so the Crown doesn't want it, and the police, and the Crown doesn't want to be blamed, and so they're focusing all this attention there. Is there an obligation on the Crown to say, we're doing a deal here with this witness, and if you know anything, you might, because had the tapes been turned over earlier...
I don't think there ever has been until now, and I think we're at the beginning of a new era. I think that because we have the charter, the prosecution has come to the view that they have no obligation with respect to fairness except whether they're in the charter or outside of the charter. And I think it's open season on everybody at the hands of the prosecution.
It's true that we don't know whether Mr. Murray knew the Crown was doing a deal with Karla Homolka. Is that right?
Sitting here, we don't know.
He must have had an idea.
But it's always a possibility when you're acting for a co-accused that somebody's going to cut a deal to hurt your client. You always have to worry about that.
I've just got a minute left here, and I'd like some informed guesses. What's going to happen? What's the ruling going to be?
My guess is that the judge is going to find that he was troubled by all of the things that happened, but he has to acquit because the law is not clear beyond a reasonable doubt, and Ken Murray hasn't committed an offense beyond a reasonable doubt.